Commission. I'll just read the notice right quick, and then we'll just launch from there. Notice of June 10th, 2019 meeting of the Athletic Commission was posted on the website on June 3, 2019. As a matter of just to establish quorum. Oh, that might be Mr. Wren. Commissioner Wren?
It is, sir. I'm sorry to be a second or two late.
Oh, not at all. Well, welcome aboard. You haven't missed anything. We just read the notice, and we're just about to get into the agenda.
Very good. Thank you, sir.
Yes, sir. Thank you for calling. As a matter for the roll, then we'll just run through the list. Mr. Hanna.
Present.
Just present. We'll do that. We know you're here. Just we have to get it on the record. So we got Mr. Hanna, Mr. Wren.
I am here.
All right. Then we've got Ms. Halbert. And then, of course, Donald Wynn, and it looks like he may be absent. And then Mr. McGrew.
Here.
All right. Mr. McGrew, he's our new member, and I look forward to his participation today. We already had orientation, so he's rip-roaring and ready to go, and so we're excited about the experience he brings to the commission. He also has a little bit of MMA background as well, so he kind of straddles two worlds, but he brings many years in boxing as well, and also from the officiating side, so that'll be very helpful. So first of all, I just want to welcome you to the commission, and if you have any questions from us, feel free to let us know, and then we'll kind of get you caught up on the history of the context of whatever we're talking about.
Hey, thank you, and I will.
All right, yes, sir. All right, we do have quorum, chair, and if you don't mind, Mr. Hanna, if you like, I can facilitate since you're in transit. Of course, any point that you would like to interrupt or do that as well, then that would be your prerogative.
I appreciate the assistance. Thank you.
Yes, sir. So we read the notice of meeting. We have quorum. I'd like to read the statement of necessity. Anytime we do a teleconference, we have to do a roll call vote on the record for each of the actionable items. Typically, we'll do a voice vote if everyone's present, but we want to make sure for the record we establish who voted on what and where. So and I'll just, without further ado, I'll read that. And then just keep in mind that after we acknowledge or enter in the statement of necessity, every vote after that, we'll do a roll call vote. According to TCA 844-108B2, if a physical quorum is not present at the location of a meeting of a governing body, the governing body must file such determination of necessity, including the recitation of the facts and circumstances on which it was based, with the Office of Secretary of State no later than 2 working days after the meeting. Furthermore, TCA 844-108A3 defines necessity as matters to be considered by the governing body at the meeting require timely action by the body, that physical presence by a quorum of the members is not practical within the period of time requiring action, and that participation by a quorum of the members by electronic or other means of communication is necessary. This is the regular scheduled meeting for the Tennessee Athletic Commission. The purpose of today's meeting, with some members attended by teleconference, is to discuss the agenda as noticed on the website earlier. We'll just have to enter that and file that with the Secretary of State's office within the next couple business days. If that statement is acceptable by the Commission, I would entertain a motion to accept that.
I'll motion to approve it.
Thank you, ma'am. Dr. Halbert, motions to approve. Do we have a second to approve that?
Second.
I'd like to second it.
Mr. McGrew also seconded it. And then for a roll call vote, Mr. Hanna?
Aye.
Mr. Wren?
Aye.
Dr. Halbert?
Aye.
And Mr. McGrew?
Aye.
All right, thank you. That's been approved. All right, we're moving on then. Now for the agenda. There's a couple things we'd like to move on the agenda if the Commission would allow and entertain that. If you'll notice on the agenda, we have the sanctioning body review under Director's Report. That might be a little bit more hardy, so since we've only got one case on the legal report, we'd like to put the review after the legal report, so we'd like to bump that up. And then also, under the Director's Report, I'd like to add the dates for the 2020 schedule as well. I know it's surprising that it's that far out, but yet we have, to make sure that logistically that we have the rooms and the facilities that we need to do what we're mandated to do. We have to kind of get started earlier. So, it seems like each year we have to get started earlier and earlier. So a lot of things happening around here. So if that's okay with the Commission, we'll add that, and then there's no other changes. If that's okay with the Commission, and we would entertain a motion in that regard.
I'd like to make the motion we approve the agenda.
Thank you, ma'am. We have a motion to approve the agenda. Do we have a second?
Second?
Mr. McGrew seconds for roll call vote. Mr. Hannah?
Aye.
Ms. Halbert?
Aye.
Mr. Lynn?
Aye.
And then Mr. McGrew.
Aye.
All right, thank you, folks. Then we'll just go down there as so ordered. The March minutes, everyone got a copy of those. Was there any comments or anything that you would like to discuss in regard to that? Any edits or anything that someone noticed? Okay. Unless there's any comments, and we'll entertain a motion to accept the March minutes.
I'll make the motion to adopt the minutes.
Ms. Halbert makes a motion to adopt the minutes as written. Do we have a second?
A second.
Mr. McGrew has seconded. For roll call vote, Mr. Hannah?
Aye.
Ms. Halbert?
Aye.
Mr. Wren?
Aye.
Mr. McGrew?
Aye.
All right, great, thank you. Okay, moving right along, we'll get right into the budget report. There's some good news I'd like to share with you, and I won't spoil it. We'll just kind of build. So we'll start with page number, the first page there. We've only got 2 pages. For the benefit of Mr. McGrew, I'd like to go over the reserves and just kind of explain some of those items there. What we're looking at, of course, expenses, total expenses, and then we're looking at revenue at the bottom. And then you're looking at those columns to the far right are each fiscal year. Towards the bottom, you'll notice at the very, very bottom right-hand corner, fiscal year 15-16, we had a net surplus of $493. So those are some really narrow margins, very narrow. You'll see the following year, we had a surplus of $32,000. And then last year, we had a deficit of $23,000. And some of those things we were able to identify. We saw that the inspections expenses were somewhat running away from us. We just had a lot more events. It was requiring folks to travel. They were all local, so a lot of these folks are having to go to these areas. So we're spending a lot of money on logistics, per diem, those sort of things. One way we tightened that up and closed off that hole was hiring part-time inspectors, folks local to the area, not requiring travel, and then we pay them a flat fee. And that's really made the difference. And then also, it's just helpful to have a big event. That big event in fiscal year 2016 and 17 was the UFC fight. And then we had another one of those this year. We're always looking at program solvency on a 2-year basis. And so I'm happy to report that things track for the last 2 months of this fiscal year will be in a net surplus. And that's ultimately where we want to be. We always like a little bit more cushion there in those margins, but we're doing okay. So that makes things a lot easier going up to for a sunset hearing. But you'll see some of the itemized items there. That's travel. Edison basically is anything that we put in that's a cost that's delineated to the departments, whether that be supply, whether that be employee benefits, and then there's some things that aren't listed underneath those accounts, but would apply to those line items, and then that comes out in administrative cost backs. You have the total expenditures under payroll expenditures. You go a little further down, and then you've got cost backs, administration, investigation, legal, field enforcement, and we'll dive in. We'll kind of delineate and separate some of that in the next one. So if you would just turn to me to the next page. Now, we did sort of a deep dive, and we covered the reserve balance, administrative cost backs, and monthly expense report through December. So this time around, we're going to focus on January through April, but I'll just go ahead and kind of review what some of those line items are. At the very top, there are the revenues, and the very bottom are the expenses, kind of in reverse order than what you were used to in that reserve itemized statement. You've got licensing revenue, which is just basically anything that we bring in for licensing, whether that be a promoter or a combatant, whatever that is. And case revenue is what we collect when it comes down to a disciplinary action that's taken. If there's a fee assessed or assigned, then what we bring in there. The state reg fee, you'll see a negative, or it looks like it's a weird place because it's supposed to be revenue, but yet it's got brackets. That's what, and this is an accountant term that I was unfamiliar with. I don't know how you put an expense in a revenue, but Apparently that's pretty common, and that was referred to as a reduction in revenue or expenses, and what that basically comes down to is it's a workaround. We don't print the licenses. F&A does that, so then we pay them $5 per license to do that. It's a nominal fee, but so it's coming out of there. So it's in essence, it really is a reduction in revenue since it's tied to the license itself. Of course, then we've got the expenses below the Edison expenses, benefits, technology expenses. Anytime we, if we're spending money to our vendor for core online system, most of the time it will come out of there. Below that, you recognize that very similar again. Anything that's not within those line items that's not already articulated in Edison, but would fall underneath those categories. That's why you see the duplicate under administrative cost backs. There's some things that it's not readily identified in Edison, or there's not a good place for it, but it's still technology. So then it falls under administrative cost backs. Administrative cost backs are in essence our share of the administrative cost backs of all the programs, which those, as you can see across the board, are pretty nominal compared to other programs. They're I'll just give you an idea. That's usually based on the overall budget as determined by accounting, but they make that based on complaints that come in, total licensee pool, things like that. So, for example, I remember the total cost backs for, let's say, Cosmo and Barber was like 16-17%. Well, that's because they've got 70,000 licensees. So that's why and whereas ours was a fraction of a percent. And so we all share the same building, so there's no way to say that light bulb belongs to this department. So you take all the expenses and then prorate it based on the size of that program and how much administrative support is going in to support that program, and then it's itemized accordingly. So that's where the administrative cost backs comes from. Legal cost backs, that would be anytime they're working on a legal report. That's a billable hour, which is pretty common to the industry. And then centralized complaints is our customer service, basically our call center and complaints. They receive, they're the first point of entry for most of that. So they also spread that across all the programs. Investigations is if we send an investigator out on a follow-up, basically on the report, inspections discover something that's going to require more than just an inspection. Now we got to open up an investigation and maybe send for expert review and the sort. So that's where we end up. And if I'll just now get to the good stuff. April, let's just flash forward. We've been running a net deficit all year long until April. That's when the UFC revenues hit the budget. So, which put us in surplus for that month of $79,000. Now go all the way, just below that, below that final line. You'll see that 26,000 number there. That's total budget. So total budget with counting the deficit and reserves. So right now the program is basically 26,000 surplus, and we've got 2 months left. And as you can see, we're not tracking anything near that. I think the highest we had 1 month in deficit was 12,000. So unless we repeat something like that twice, we're gonna clear this program in a surplus. So that was the good news. But another reason why we want those big shows and those programs to come here. All right. That was just for informational purposes. If there's any questions in that regard, that's probably more than you wanted. We won't do that all the time, but given the circumstances, I wanted to make sure we dived in there a little bit and unpack some of that. Okay. We'll move on then. We'll just move to the dates, since we're going to do the sanctioning body review after the legal report. Each year we try to calendar those dates out in advance. Basically, the dates that I picked are they mirror what we've done the last 2 years. We have, by statute, we have to do quarterly meetings, and so as a result, that's what we have here. We're just meeting our mandate, and it's I think it's the second Monday, or I want to say like the second Monday of every quarter of that month. So that's where they landed the way they did. If that works for everybody, we'll just need a motion in that regard. Let me read those dates for those of you that are on the phone. That's March 9th, June 8th, September 21st, and December 14th. Now, all of those dates will be posted on the website, and then of course I'll send you out reminders as we get closer to the meeting as per usual. Any questions on those? Yes, sir.
Could you run through those dates one more time?
Yes, sir. March 9th, June 8th, September 21st, and December 14th.
All of these are the second Monday of the month, of each month, is that correct?
I believe that's how that falls. I'll have to check, but it's basically on the same pattern that we've had the last several years. We tried that way. It's not any surprises, but I believe that's the case. All right. In that regard, do we have a motion to whether approve or otherwise? And then, of course, we can discuss that if there's any comments to follow. Do we have a motion?
Make a motion that we accept the meeting dates for schedule 2020.
Okay.
I'll second it.
We got a motion from Mr. McGrew, and then we have a second from Ms. Halbert. For roll call vote, Mr. Hanna?
Aye.
Ms. Halbert? Mr. Young?
Aye.
And then Mr. McGrew.
Aye.
All right, thank you very much. And if I can, just for a quick moment, I would be remiss if I didn't make one more introduction. It just occurred to me that we have a new assistant commissioner as well, Mr. Toby Compton. He introduced himself earlier to some of our members, but some of those on the phone, just want to let you know that Carter is, since he's moved on to be our deputy commissioner, and right now he's stepping in as interim commissioner as well. So I can assure you that Mr. Compton and all of his staff will provide the support that you need and require, and always happy to help any way that we can.
Welcome, Mr. Compton.
He says thank you. He's observing right now, but he's not at the mic. But he's here. He's watching and listening, and pleased to be a part of what's going on. So we've thrown him in the fray a little bit in some of our TAC meetings, our staff meetings. So we're enjoying the interaction, and I can assure you he's got a steep learning curve, and things are moving well. So you're in good hands. All right, we'll move on then to the legal report.
Thank you. This is Erica Smith. I'm the disciplinary counsel for the Athletic Commission. This is my first meeting with y'all, so I'm going to just go ahead and read the one and only case on our legal report verbatim, and if you have any questions when I'm done, we can talk about those. The case number is 2019-016311. An inspector noted that when he went to verify the presence of emergency service workers at a boxing event, there were 2 firefighters/paramedics on hand with all necessary life-saving equipment in compliance with statutory requirements. When the inspector inquired about an ambulance, the lead fireman informed him that county ambulances were on a 24-hour rolling patrol, and they were in constant contact with the crews by radio. The firefighter also stated that the response time would be nearly instantaneous, and they could contact the ambulance crews at any time with the radios they were wearing around their shoulders. After verifying the presence of all necessary life-saving equipment and in consultation with his supervisor, the inspector allowed the fight to proceed. So according to our statute in Tennessee, 68-115-404F1, which states an ambulance or other emergency vehicle shall remain on the premises at all times during a professional contest. And then our federal Professional Boxing Safety Act of 1996 under 15 USCA section 6304. That states in pertinent part, except as otherwise expressly provided under regulation of a boxing commission promulgated subsequent to October 9th, 1996, an ambulance or medical personnel with appropriate resuscitation equipment continuously present on site. So my recommendation would be to close this matter with a letter of warning citing these statutes and this federal regulation, seeing as the inspector allowed the fight to continue, his supervisor approved it, and there was an ambulance pretty immediately available. But I think it's important to inform this promoter that in the future there needs to be one on site no matter what. Thank you.
Any comments in that regard?
Is this the first time that this particular incident has ever happened with this promoter?
Yes.
How many shows has this particular promoter put on?
Well, they were just licensed in January, so I'm not sure. Do we have that in our records?
This was first.
Okay.
First one, okay. Questions?
Since we only have one on the agenda, and since it was read in the record as well, we can just take a motion on this one whenever you're ready.
I have one other question. So, does the letter of warning go in a file? How does that?
What happens, a letter of warning is considered a private discipline, so it goes in the licensee's file for as long as they have a license, really forever. So if the licensee was to get a complaint in the future, whether it's similar or different, the disciplinary council always can see that, anything in their record, whether it's public or private. But no one else would see it but the licensee and us being private. You're welcome.
Mr. Kopchak, I don't have any other questions. I'll make a motion to entertain the warning.
All right, we have a motion from Chairman Hanna to approve the council's recommendation and to close with letter of warning. Do we have a second in that regard?
Second.
All right, Mr. Lynn, thank you for that. We've got a motion from Chairman Hanna and a second from Mr. Lynn for roll call vote. Mr. Hanna?
Aye.
Ms. Halbert? Aye. Mr. Lynn?
Aye.
Mr. McGrew?
Aye.
All right, thank you very much. We can dispense with the legal report then. We'll move to legislative updates then. We've got just a couple. They're just this will be the brief portion of that regarding the amateur deregulation and the unified rules, weight classes. Those were something that you've seen before. There's something that we've been in discussion with, voted on several meetings ago, but they will be effective.
This is Pam Spicer. We have an effective date of August 6th. We anticipate that we will be in front of the Joint Government Operations likely in July on this to answer any questions that they have up at the legislature, and then these rules will go into effect August 6th. That is for the amateur deregulation and also for the weigh-in issues that you all addressed and the apparel and weight classifications that have been amended. I do want to also speak, we have, as you all know, two other sets of rules that have been combined into one. Just to refresh you all, that is about the protective equipment, female boxing, and the ring, allowing a mixed surface to be used on the ring. Those are currently have been approved by the department, but they are at the Attorney General's office for pre-review for constitutionality. As you all know, the process is lengthy. The AG's office will let me know if they have any edits. Then I will make those edits, and depending on whether they're substantive or not, we will get back with you on that.
All right, and Mr. McGrew, just to give you a quick, just sort of overview, the amateur deregulation was we had a rule basically that said that all sanctioning bodies, amateur sanctioning bodies, had to have rules as strict or stricter than the pros. As a result of that, that was a bridge to an on-site ambulance and the full medical insurance that the pros would carry, which wasn't, when that was written in basically as an emergency set of rules, and it unintentionally caught all the feeder organizations, like, the 11-year-old kids with the padded helmets, and some of the point kickboxing and some of those sports, and that wasn't what that was intended. We didn't want to over-regulate those or unintentionally regulate those when the intent was to pass that regulating onus on the sanctioning bodies. And of course, we approve the sanctioning bodies and make sure that their requirements maintain the health, welfare, and safety of those participants. But and then of course our responsibility is with the pros, as everyone already knows, and so we just provide some carve-outs in those to make sure we address that, and so that we don't unintentionally regulate a lot of folks that we weren't intending to do so in the first place. So that was that piece. The unified rules, weight classes, and all that, you're familiar with that with ABC Boxing. That we're just adopting much of what they've already accepted. We're just inculcating that into our rules. And then the new set of rules, and those last two will be August 6th. The new set of rules, the female boxing rules, was just to get that more in line with the sport itself. And Dr. Helber, she really assisted us in that regards, and the commission a couple meetings ago ruled to accept those red line items, and then those are in the process. And the process typically takes about 9 months, generally speaking, for those to become effective. And same with the vinyl mats. We have a rule that stated that anything that was a vinyl mat was prohibited. Well, technology's come along the way where there's some hybrids that are very safe. We don't want the purely vinyl mats because they can get sticky and wet, so people will slip and fall, or if they break, they can lacerations, especially in MMA, as folks are spending a lot of time on those mats. And so, but there are a lot of hybrids that were getting, again, caught up in that as technology changed. So then the commission provided some discretion for this commission and administration to make those determinations so that we don't sort of bottleneck the industry unnecessarily with outdated rules. So we just everything's kind of coming up to date with the industry. So that's what that is. And if we may, we'll move on then to the next item. I guess we can you want to do the training update? I guess that was what we had next then. We'll do the review. I think that's what we had moved. We're going to save that training for last, I believe. Yeah. So we're going to move to the sanctioning body review. And if I can approach the platform now, kind of help you with some of those resources. Those of you at home, I was just showing our commissioners here where our rules and laws are. Those of you at home that have access to that, you know where that's at our website. But in case we reference some of those, and if you have any interest in wondering where that's coming from or want to look at that, if something was to arise or reference, then you have the option to do that, of course. So since you don't have your laptops in front of you, want to make sure you're aware of that. Okay. Let's just... Primarily what we're looking at is the Rule 145-05-02 states the following. We're going to frame it up with this, okay? The Commission will approve and recognize those amateur sanctioning organizations that are able to enforce or establish and enforce rules as strict as or stricter than those established by the Commission for professional unarmed combatant contests. That was the old rule. The new rule that's going to be affected here, that's coming into effect on August, basically reduces that to conduct. So we're primarily looking at conduct. So what it comes down to is the rules that you see in the package that USF MMA provided, which looks like it's an offshoot or off branch from UMAF. So a lot of the same board members, a lot of the same personnel. Looks like they're kind of forming internally. There's an organization forming out of that. You'll see a lot of similarities there. But what we're looking at for our purposes will be primarily pages 10 through 18, which is their protocols, their rules, and regulations. And then we're looking at conduct. Now, there's a broad discretion in what sanctioning bodies that the Commission can approve, and the question you want to ask yourself is this a sanctioning body that you want regulating amateur events? Okay.
Is there a representative of USF MMA here?
Mr. Brown? Okay. They were made aware that they have the opportunity, but it doesn't appear that anyone's present. So I guess we have to go on what we have in front of us. Please. Sure. Yes, ma'am.
Are they... I read in their materials that they are seeking national governing body status with the USOC. Have they gotten... do they fall under the USOC, or is that something they're still trying to achieve with USOC?
they're currently operating as far as a sanctioning body in South Carolina, North Dakota, Minnesota, Michigan. They have pending licenses in review in Virginia, Florida, Nevada, New York, and with us. No, they don't. They don't have that recognition yet. They are seeking it, but until they have that, we're basically left with what they have before us.
This organization, where else do they participate? Other states, have they?
Just South Carolina, North Dakota, Minnesota, and Michigan. That's where they're at right now.
Is there any record of any type of particular problems that they have had in the past?
Honestly, there's just not enough record. A lot of these other states don't. They're much like Tennessee. They recognize the sanctioning bodies and then leave the regulation to them. Now, it's not a hands-off thing. One of the things we've been wanting to do is perhaps get more proactive with that and do more spot checks. But really, you're left with the with the governing body that they represent. It's these are our rules and trust us is kind of where we're at right now.
Their national office is Nevada, is that right?
I believe so. Let me take a look.
It's at least where Ralph, their director, he was the state director for the ISKA in Nevada for 6 years, but
Mr. Brown, the regional director or the state director here, he's the one that submitted the license. So it's the chapter making the application. Any other comments or concerns? This would be the opportunity to do that. And again, if we just feel like we just don't have enough information, we can table this and bring this back before the commission, or take it, line item, or however you want to go about that.
Do we have a list of the sanctioning bodies we recognize currently?
We do. If you were to, I believe it's on the website. It's a little bit buried, but there's 6 right now. I don't have that list in front of me. USA Boxing is the only boxing, sanctioning body, but then the other 5, ISKA, World Kickboxing Federation, UMAF, those are the ones that I can on top of my head tell you, but there's 5 of those. I believe it's under applicant resources, or no, I think it's the schedule actually, now that I think about it. If you were to go to in that area and the frequently asked questions, I believe it's there as well, at the very top in that border. Now that I can see it now in my mind's eye, that's if you go to FAQ, which is the very top, and then they have a bunch of information there, articles at the very top. The banner lists all of those.
This would be the 6th MMA Federation and the 7th overall. Is that correct?
That's correct. And keep in mind, UMAF is already sanctioned. Mr. Haney, when was the last time, do you recall, that we approved a sanctioning body? I believe we're the only one that could provide that historical for us. I wasn't here at that time.
well, as I get older, years kind of run together. But I would shoot from the hip and just tell you it's. I want to think it's been probably 6 years ago, 5 maybe. I can't say for sure.
Right. It's been some time.
Just based on the conversation, just for the board, for what this is worth. From conversations I've had with Mr. Kopchak and just reading through the material that they've provided us, there's certainly enough on paper. There's certainly enough experience. If you just look through their board of directors, Ralph Cook being one of them, he's worked for several years with King of the Cage, which is a pretty respectable MMA environment. They've got Dominic Cruz on their board, which is you won't find any more versed or experienced MMA. And so I'm, I guess and this is one of the questions I asked earlier was how many do we need? But I also don't want to pretend to try to play God as a board in determining, this person for no other reason than just having too many does not get to regulate or have their shot at regulating Tennessee mixed martial art or boxing. So personally speaking, I don't have any other questions, and I don't really have any opposition to considering these folks.
If that was if the board, was to move into the direction of considering their application based on what they've provided, then we'd have to look at pages 10 through 18, and then based on what the industry experts, the commission, and those of you that are participating today, you would take a look at what they've provided, and do you feel comfortable based on what they're providing on each of those items that the combatants or participants would be safely able to conduct that event based on what they're providing. So we would have to take it basically piece by piece. And that might be something just we digest right now and then come back in another quarter when we've had an opportunity to carve it up a little bit further.
I would like to take maybe a little bit more time to digest some of this.
Any other comments? Okay.
I don't see, Mr. Kopchak, I don't see where us taking a little bit more time to look more deeply into this is going to put us as a commission or our state or our competitors in any bad situation. We do have, as was pointed out, a number of sanctioning bodies already. And I think it's, right that we do our due diligence on this thing and make sure if we're gonna roll over and do some more, that they do totally meet the requirements that we think are, what should be fulfilled in our state. I take pride in the fact that when we put on a contest in this state in a professional manner, that it's done at the highest level. That's what we owe our constituents, our players, and I think it's we've got time to really look at this and make sure it's what we want.
Okay, that sounds great. In that regard, then, we'll roll this over, table this until our next meeting. And basically, just to let everyone know, the commission has broad discretion here. You're the industry experts. So we're depending on the commission to, look at their regs and their rules and let us know, are those safe? Or if someone was to conduct an event with those rules in place, would we feel comfortable giving our endorsement to that in this state? So, what I would do is take those rules 10 through 18, and that's really, Chairman Heenan did a great job bearing out the qualifications of the directors and organizing body. So I don't think anyone has any question about their qualifications. So the issue here really is their rules and regs. So that's the heart of what we're having. So like a laser, we really want to focus on pages 10 through 18 and just look at those rules. Are we comfortable with those rules? And if not, just when you're drinking your coffee in the morning, just take a pad and go through those and make your notes. We'll come back here, have a work session, and we'll do this by the numbers. Okay, is everyone fine with that?
I like it.
Fine.
All right, sounds great. Thank you so much. All right, well then we'll move on into the next item. This is the member training refresher. I know it's a time of year that everyone looks forward to. So, This is basically just that boilerplate template HR stuff that we have to go through to maintain our compliance. But it's important information too. And I say that in jest, but it's good information. It's things that oftentimes when I do the refreshers that I have to do each year, it kind of jogs my memory and keeps me on the right track. So legally, we'll go ahead and dive into that, and that will be available there on your iPads for those that are here present, and then those of you at home, that was of course sent to you, and you'll have access to that, and she'll be going through each of those items. So I'll just yield the floor to her, and we'll go from there.
Good afternoon, everyone. Again, this is Pam Spicer, and I'm going to be going over both the Open Meetings Act, the Open Records Act, and a case that is important to all boards known as the North Carolina Dental case, which was in the Supreme Court. You all may have received this training in the past, but as you know, we need to do this annually. There's also, I believe, a separate requirement that Glenn may want to speak to. This is separate from the YouTube training. That's a 12-minute video that you all need to watch. This is separate from that. This is a separate requirement.
Those of you that are on the phone, Mr. McGrew had the pleasure of conducting that training today as a part of his orientation. But those of you that have been with us for a little while longer received that link in the email from Ms. Gamusio. And if you don't have it, as a matter of fact, since I'll go ahead and just as a precaution send that out to everyone again. But the idea was for Ms. Gamusio to send that out to each of our members, and then just acknowledge that you've received that and viewed that video. It's as part of the executive order by our governor to make sure, as part of his move towards transparency in government, we just bringing up that open records training again for everyone, and open records and meetings training there. So it's a 12-minute video YouTube link. If you get that from me, that's what that is. Just acknowledge that you've received that and went through that, and then we'll be good to go on compliance. And of course, the council will touch on that a little bit today, but that was a good point that she made. That's a separate item. So if we'll still need some action from you in response to the link sent to each of you. So and your assistance there will be appreciated. Thank you very much.
I'm going to go a little bit out of order with the documents you received and start with the North Carolina Dental case. This case is effectively titled North Carolina State Board of Dental Examiners versus the Federal Trade Commission. This was a 2015 United States Supreme Court case that basically dealt with immunity of state boards. Particularly, this case dealt with the dental board and whether it could allow non-dentist or prevent non-dentist from providing teeth whitening services. Ultimately, the Supreme Court held that the board did not have antitrust immunity. Basically, what this case is discussing and trying to basically protect boards is that you all cannot engage in anti-competitive behavior. So, for this particular case, if the dental board made up of dentists is saying that non-dentists, which is what they said, can't provide teeth whitening services, the Federal Trade Commission brought lawsuits on behalf of the Federal Trade Commission against the board, and the Supreme Court sided with the Federal Trade Commission. What Tennessee has done to protect you all, because the problem is you could be sued individually. And so what Tennessee has done is enacted a statute, TCA 4-4-126, in order to protect you all. What that does basically is designate an individual, and this is contained in the materials you received, to act as a supervisor and review the board actions. So you're not out there acting on your own, basically. And that's contained in the materials you received. And it specifically provides that each supervising official shall ensure that the actions of the regulatory board that displace competition are consistent with a clear and articulated state policy. Basically, what would happen is if you had a board meeting and the policy director decided that we may need to review that, provided in your materials, you would be notified of that, and then we would review that within so many days if you did take an action that could be subjected to scrutiny. Probably several of you have gone over this in the past, but I'll be happy to answer any questions that you have related to that case. If not, I'm going to go forward and start on the open records, and then I'll go through the Open Meetings Act. Basically, for purposes of open records, this can be found in TCA 10-7-503. Basically, the best way to handle this is to consider everything that you do in your official capacity an open record. While this statute identifies some specifics like documents, papers, letters, maps, books, photographs, the best and safest route is to consider what you do as this board subject to the Open Records Act. I'll then speak to the Public Meetings Act. This sometimes generates questions with board members. Specifically, what the Public Meetings Act does is make sure that all your board business is conducted in a way and is accessible to the public. It applies to you both as an individual and as a board. Anytime you are gathering, if you gather in the form of more than one member, it is considered a meeting. One thing to note is one item that is not considered a meeting would be an executive session. For example, if there was a lawsuit pending and there was something that you needed to discuss with the attorney, you could call an executive session. So I do want to point that exception out. You cannot make any decisions at that meeting if we have an executive session, but we can deliberate. You can't deliberate, but we can discuss the matter and then bring it before the full board. You all are aware, but I'll go over that you are required to give notice of every meeting, and we normally give notice of the meetings on the website. One issue is if, for example, you have a meeting that should be subject to the Open Meetings Act, anything you do during that meeting that is not open to the public would be obviously null and void. So that's good to keep in mind. I want to give another example because this also could come up. For example, emails. I think contained in the materials, and I don't know the page number, it even discusses emails and gives examples of emails. Anytime you are discussing board business, my advice is it's best probably not to do that in the email form with other board members. There's nothing that can't wait to a board meeting, and if it's something that affects the health, safety, or welfare of the citizens of Tennessee, you would need to let the executive director know, and that individual will get with legal, and we will determine if we need to call a special session, a special meeting to take some form of immediate action. But you really should not be discussing board business with each other in the form of an email.
Makes perfect sense.
We kind of went over this today. I'll just touch on it because we have had to do this in this particular board meetings in the past. Of course, electronic attendance, as we've done today, everything needs to be done by roll call vote, which this board is familiar with.
try to create some protections for you. Like you'll notice when I send you an email, I blind copy everyone. That way, if you were to reply all, you're only getting myself and our attorney, and then that would be protected information. So, we try to set you up for success. And of course, when we're here, our legal staff, they do a phenomenal job inserting where those protections and where the boundaries lie. And so they're always ready to provide that counsel and to keep us on track. And then, of course, then we have a policy director who reviews each of that as well. So there's many layers. We're all working together as a team in that regard.
Does anyone have any questions about the materials that were provided?
Well, in that case, and if you have any questions, we're always available. You've got my information. You've got Director Gamusio's, and also Ms. Spicer. So if you ever need to reach out to us, we're available and always willing and glad to be of assistance any way that we can. Is there any new business that anyone would like to cover or would like to address? Okay. Unless there's any new business, we will entertain a motion to adjourn. Do we have such a motion?
I make a motion to adjourn.
All right, we've got a motion from Mr. McGrew to adjourn. Do we have a second?
Second it.
All right, Dr. Halbert is second for roll call vote. Mr. Hanna?
Aye.
Dr. Halbert? Mr. Wren?
I would like to welcome Mr. McGrew and say aye at the same time.
Hey, well, that is more than welcome, and I hope he feels that from all of us. Well, we're so glad to have him here. Thank you, sir, for that sentiment. And then Mr. McGrew.
I'd like to say thank you for that welcome, and I will do my best to serve this board in any capacity that I can be of assistance, or I'd like to be an asset. And I also say aye.
All right, well, then that settles it then. That's the point we want to end on. So I'll close this out, and then we'll call it. Thank you.